Hello and welcome to our very first episode of Agent Counselor. Here on this channel, I am going to break down legal updates and cases that affect you as a real estate agent. And I'm hoping that with this knowledge, with this insight into the law that really only attorneys have and are trained to understand and interpret and guide, that you as an agent become a sharper, stronger, and more polished professional. So before we begin and break down our first case, I got to tell you, this video and all videos that I post do not constitute legal advice. Your particular situation, your client's particular situation, there's a whole lot of facts and variables, circumstances that could change any given legal analysis. So make sure you seek legal counsel for your particular situation. But these videos are really designed to give you an insight as to how the courts might be looking at a particular situation so that you can really thoughtfully and carefully better navigate the circumstances that you find yourself in. All right, so if anything, knowledge is power for the real estate professional, and that's what this channel is designed to do, is give you that knowledge so that you become that sharper, stronger, more professional agent. All right, so our first topic on this channel is going to be something that is going on all over the place in the real estate market right now, and that is buyers submitting offers with non-refundable earnest money provisions tied to those offers. And the reason that most buyers are doing that is because they want to strengthen their offer. They're essentially saying, hey seller, I'm going to send you this offer, and right upon acceptance, you're going to lock in that earnest money, and you're going to know that if I back out for any reason, that earnest money is yours. And the intent, like I said, is to make that offer more attractive, stronger, as it competes against multiple bidders for the same property. But what are the legalities surrounding that? And how would the courts interpret a contract where the earnest money is non-refundable upon acceptance? Well, the case that we're going to look at that sheds a little bit of light on this subject and at least gets your wheels turning of maybe how to handle that situation, or if it's a good idea at all, comes from the Idaho Supreme Court. The ruling was handed down in 2017 in a case called Phillips v. Gomez. So let's take a look. Okay, so you see the case right there, Phillips v. Gomez. So we're going to go through this. The facts in the background are laid out here. So essentially the facts are pretty straightforward. We have a seller who lists the property for sale, and along comes a buyer. The buyer offers $660,000, and 10% of that is earnest money. So it was a $66,000 deposit. Well, the contract had amendments, and the contract provided that the earnest money deposit of $66,000 was to be non-refundable following the inspection of the property and Gomez's attorney's review and acceptance of the contract documents. And so essentially what we have is an offer with an addendum. And the addendum makes the $66,000 earnest money deposit non-refundable after the attorney, the buyer's attorney, reviews the contract and the acceptance, and the due diligence deadline passes. At that point, the earnest money is hard and the buyer cannot get it back. So the transaction moves forward, and Gomez pays the $66,000 into the broker's trust account, and Gomez is permitted to move into the property under a residential lease. The entire $66,000 was then released from the trust account and paid to the seller, presumably after the due diligence deadline here passes. It doesn't say, but that's what we're presuming. A little bit of that money goes towards the real estate agent's commission, but the $62,000 balance goes to the seller. As time goes on, Gomez cannot close on time, and the parties begin negotiating. And so essentially, the problem goes on over time. We have Gomez not being able to close on time, they renegotiate, and again, the deadline comes up, Gomez can't close, they renegotiate, and finally, it just comes to a head and the deal falls apart. So the seller puts the home back on the market, finds a new buyer, but the problem was that the new buyer, their offer was accepted for much less than Gomez's original $660,000 purchase price. So the seller is feeling like, I lost a buyer at $660,000 and I picked up this new buyer for $520 something, and that's a big difference. So I'm damaged. Because that first buyer couldn't close, I have to get this buyer who can't pay as much. Therefore, what does the seller want to do? Seller wants to sue for damages, for the economic loss that Gomez left him for having to take this second buyer. So the seller sues. However, at the trial court found in favor of Gomez and ruled that the seller had no right to sue because of that earnest money deposit being non-refundable. So on appeal, the case goes up to the Idaho Supreme Court. So we're going to start with that second paragraph, the district court there, to give you a chronological chain of events. It says the district court, on the other hand, found that the amendments to RE 21, which is the purchase contract in Idaho, making the earnest money deposit non-refundable and immediately available to Phillips without restriction, was to work an advance election of remedies to accept the earnest money deposit as liquidated damages. So essentially, the district court found that that non-refundable earnest money provision made the seller essentially elect in advance their remedies before a breach ever even occurred. And that's what this whole case was about, was did that non-refundable provision make an election in advance of the remedies? So it goes up to the Idaho Supreme Court for their analysis. It says at the top there, Phillips contends that he never accepted, elected, or agreed to accept the earnest money as liquidated damages in lieu of his actual damages when he contracted to make the earnest money non-refundable. Rather, Phillips maintains that he elected to proceed with an action to recover the trust's actual damages of approximately $60,000 over and above the amount of the earnest money Gomez released to Phillips. Thus, Phillips contends, although he accepted the earnest money, he never accepted the earnest money as liquidated damages. Phillips maintains that there is no language anywhere in the agreement between the parties suggesting Phillips accepted, elected, or agreed to accept the non-refundable earnest money as liquidated damages, or that Phillips had conceded or given up his right to make an election to accept earnest money as liquidated damages, seek specific performance, or seek to recover its actual damages. And the court says Phillips's argument is unavailing. So, bottom line here, to this point in the case, the court's just going through the arguments, the arguments that the parties made, and seller's saying, look, when I accepted that earnest money provision, that addendum, I never intended that to be an election of remedies. I wanted to retain my right to sue for performance or my right to sue for damages. So no, court, I didn't elect my remedies at the forefront. All right, so let's look at the analysis that the court goes through. First of all, the court establishes the law. The court says that amended agreements should be construed together with the original agreements where possible, and it gives some precedent that establishes that. The court says, however, addenda are controlling over any inconsistent provisions in a pre-printed fill-in-the-blank agreement. And further, a party's subjective intent is immaterial to the interpretation of the contract. Instead, courts will give full force and effect to the words of the contract without regard to what the parties of the contract thought it meant or what they actually intended it to mean. So there's the law. The court is saying, look, the words in the contract matter. And where possible, we are going to take addenda or amendments, and we're going to make sure they reconcile with the whole agreement. But keep in mind, the law says that amendments or addenda to contract, if they are inconsistent with what went before, those addenda will control. They will knock out what went before, and they will establish new terms for the party. And speaking of those terms, the court further says that the intent of the parties is irrelevant. What the parties put in the contract and what they signed their names to in agreement, that's what controls. So we don't bother with the intentions of the parties or what they meant when they wrote it. What we're looking at is what the words mean. And if those words conflict with what went before, that's what we're going with. Because the court is essentially saying it's not our job to write the contract for them. It's our job to look at what the words on the page say and then give those words the effect of law. Okay, so let's take a look at how the court breaks this down. Court says here the rights of the parties were defined by the agreement. Under the terms of RE 21, the amount of liquidated damages for this agreement was to consist of the $66,000 earnest money paid by Gomez and held in the broker's trust account. All right, pretty standard stuff right there, right? We got the earnest money deposit, accepted contract, paid to the broker's trust account. So far, pretty standard across the board. In the event Gomez defaulted, paragraph 28 of RE 21 gave Phillips the option of either accepting the earnest money as liquidated damages or pursuing any other lawful right or remedy to which Phillips was entitled. Thus, before the addendum amending the form agreement, the earnest money would not be turned over to Phillips until or unless one of the following events occurred. 1, it was credited against the purchase price at closing. 2, the broker turned it over to Phillips as liquidated damages in the event of a default, if Phillips so elected. Or 3, in the event Phillips elected any other lawful right and or remedy to which Phillips may be entitled. It was to be separately held pending the resolution of the matter. All right, so this remedy provision in RE 21 is very similar to most remedy provisions in the different purchase contracts from that vary state to state. Most purchase contracts in residential real estate offer the non-breaching party these 3 remedies, and the contracts usually say that that non-breaching party can choose one of those 3 remedies, which namely are accepting the earnest money as liquidated damages or some amount equal to that if it's the buyer who's not breaching, the right to sue the breaching party for specific performance and make them go through with the purchase or the sale, and 3 is the right to sue for any other damages or other remedies available at law. So again, pretty standard stuff, and the court is saying that's what the agreement was, and that's what the agreement said before we added this addendum. The court says, however, the parties amended and added terms to RE 21, making the earnest money non-refundable and immediately available to Phillips without any restrictions. The amendments did not make any mention of what would happen if Gomez defaulted and Phillips decided to pursue actual damages instead of liquidated damages, being that Phillips had already transferred and retained the earnest money 13 months prior to the scheduled closing date. All right, so the contract offered 3 options, and then we amended the contract and said that the earnest money was going to be non-refundable at a certain point. And then we didn't really say anything else about the remedies. In the remedy section, they all discuss the earnest money. The earnest money is either the liquidated damages and it's received, or we apply the earnest money towards the purchase price and we can sue for performance, or we keep the earnest money in trust and we sue for any other damages available at law. But here we have an addendum that changes the nature of the earnest money. Therefore, it changes the nature of the available remedies, because no longer can we keep the earnest money in trust because it's now non-refundable. The nature of it has changed. It's immediately available to the seller by contract. The court goes on and says the parties could have stipulated that such retention of the earnest money is not an acceptance or election of liquidated damages. However, the parties did not do so. Therefore, a plain reading of the agreement indicates that Phillips pre-elected his remedy for Gomez's breach of contract. All right, so that's an important part right there of the opinion. The court says, look, you guys could have stated that the earnest money was not to be treated as an election or a pre-election of remedies, but you didn't. So all we see is that this non-refundable thing changes how the earnest money is treated in the remedies section, but the remedies are not reserved in the change. So we got no choice. You guys changed the nature of the earnest money, you made it non-refundable. So, and without reserving the rights to other remedies, that's your remedy. The court then finally notes that the language of the agreement is free from conflicting interpretations by reasonable persons. It is clear that Phillips initially, under the terms of RE21, had the option of accepting the earnest money as liquidated damages or bringing an action for recovery of actual damages. However, when the parties amended RE21, thereby making the earnest money non-refundable and immediately transferable to Phillips, Phillips pre-elected the earnest money as liquidated damages regardless of what Phillips subjectively intended. Now I want to read this final paragraph here. Puts things into kind of an overall summary. Court says here, Phillips retained the $66,000 earnest money deposit as he rightfully could do, but then brought action against Gomez for the remaining actual damages after crediting Gomez the $66,000 kept by Phillips. Phillips is trying to expand the limited right of retention into a right to keep the deposit and apply it to whatever larger damages he can establish. The contract does not so provide. Though Phillips contends that the earnest money was a down payment toward the actual damages, there is no plain language in any of the 5 documents showing that this was the party's intent. Such a clause that allowed Phillips to keep the earnest money and pursue actual damages would have been easy to include and should have been included if that's what the parties so intended. The default clause in this agreement gave Phillips the option of accepting the earnest money as liquidated damages or pursuing any other legal right or remedy, but it did not give him the right to do both. Because the parties did not expressly reserve such a right, the earnest money as liquidated damages is Phillips' exclusive remedy. Accordingly, no cause of action for actual damage remains to him. And in that final paragraph, the court is putting a nail in the coffin on the seller's argument that you can't take the earnest money as it applies to liquidated damages and claim that it is part of the overall damages. And it's just kind of a credit towards the bigger sum of the damages that the seller incurs. So, pretty important case here. There's a couple significant facts you really have to pay attention to. That is, 1, the earnest money went non-refundable at the due diligence deadline, and the attorney's review of the contract when the contract was accepted. And secondly, that the earnest money was actually released and given to the seller who accepted it. And in a lot of jurisdictions, we got case law that says once that earnest money is received in hand, that is the chosen remedy, and you've lost the right to sue. So right now in the market, we're seeing a lot of contracts come across where the earnest money is not being released, but there's a provision in the contract saying earnest money is non-refundable upon acceptance. So what happens? We don't really know. What we know is that this case kind of paves the path of what argument a buyer's attorney could make against the seller who's trying to sue after a non-refundable earnest money provision is accepted. That buyer's attorney can make the case just like the attorney did in Phillips that says, hey, look, the contract allows the earnest money to be used in different purposes. It can be liquidated damages. It can be held in trust while we work out a lawsuit for damages. But when you make an addendum, and it changes the nature of the deposit to be non-refundable, it changes the nature of what it was set up originally in the contract, and therefore it becomes a pre-elected remedy because you can't do anything else with it. So, for you guys, let me just say that I hope this case, pricks some curiosity and gets you thinking about, is non-refundable earnest money a good idea? I would honestly say, looking at this objectively, by itself, probably not. It probably would invite that argument that a buyer's attorney could come back and say, hey, look, we got precedent in Idaho that says non-refundable earnest money, well, it changed the nature of the earnest money. No longer can it be held in trust while we work out a lawsuit. Therefore, it is the liquidated damages. That is your only remedy. I mean, this case really kind of paves that path. So, if you're curious, make sure you talk with your broker. Make sure you consult with an attorney on this issue. Certainly have your clients consult with an attorney if they receive an offer with a provision making the earnest money non-refundable, so that they have good, clear guidance on what to do from a legal perspective. Because the bottom line is, we don't want to be the test case where the earnest money was accepted as non-refundable in the contract, just not released and accepted physically. So, hope you like this video. Hope it gets you thinking. The bottom line is the court said, hey, you can still preserve your remedies and accept the non-refundable earnest money provision. So maybe you talk to your broker or an attorney about that and getting the right language in the contract to make sure that the seller can preserve the remedies, that it's not a waiver of an election of remedies in the event of accepting non-refundable earnest money. Hope you liked the video, guys. Hope you liked this case. Hope it got you thinking. Make sure you hit the subscribe button because I'm going to be coming out with a lot of these. We're going to break down cases on all different topics. So drop me a comment and let me know what type of case, what type of topic you would like to see me break down if there is a court case out there that really hits that issue. And I will drop a link in the comments as well for the case we just reviewed, and that way you can go and you can take your time studying it and reading it and really geeking out on this stuff like I do on a Friday night, right? So again, hit subscribe and you'll get the notifications when we post the next one, and I will see you in the next video with the next case.